Hey folks, I'm attorney Roger P. Foley, and today I'm going to talk to you about one of the leading cases in Florida regarding stand your ground. And that case, just for your knowledge, is Brethrick v. State of Florida. And this is a case where an individual, Brethrick, was charged with aggravated assault with a firearm, and he asserted a self-defense claim for immunity under the stand your ground. Right? Basically, he said, listen, yes, I used my gun. I used it to stand my ground in self-defense. And ultimately, the court said no. So I wanted to make this video. I'm going to make a bunch of these videos talking about stand your ground and the statute. So let me first talk about the facts in Brethrick, and I'm going to read here right from the case law. And it says, the defendant, Jared Brethrick, was charged by information with aggravated assault with a firearm under Section 784.021, subsection 1A. Now, the facts of the case was that on December 29, 2011, the Brethrick family was on vacation in Central Florida. Let's see if I can move this up a little bit so I can read it and look at the camera. The father was driving in the middle lane westbound when in his rear view mirror, he saw a blue truck rapidly approaching them. The truck almost sideswiped them as it passed them in the right lane. As the truck passed the Brethricks, the driver, Derek Dunning, stared at them in a threatening manner, but made no statements or gestures. Dunning's truck cut in front of the Brethrick vehicle in the middle lane, slammed on the brakes, and came to a complete stop. There was no traffic or other impediment that required this action. Ronald Brethrick also stopped his vehicle 1 to 2 car lengths behind the Dunning truck. Basically, car goes right and quick in front of you, slams on the brakes, you slam on your brakes, and we don't know why, right? But that's what this vehicle does. Dunning got out of his truck and walked towards the Brethrick vehicle. He was unarmed. Without exiting, Ronald Brethrick held up his firearm, right? He showed him his firearm, which was actually in a holster. And Dunham returned to his truck without uttering a word, right? Okay, now you go, okay, that's reasonable. I would say that's reasonable all the time, right? Someone cuts you off on Highway 95, slams on their brakes for no reason, gets out of the car and comes at you in an aggressive manner. Yeah, you should be able to show your firearm, right? Stand your ground in this matter. Well, what happens is the case goes a little bit further. This guy, Dunning, gets back into his truck, and Ronald's adult son, right, Brethrick's son, got out of the rear passenger seat. He approached his driver's side of Dunning's truck within a few feet of the driver while pointing the handgun at Dunning, right? Because now, basically, the guy cuts him off, gets out of the car, gets out real aggressive. This gentleman pulls out his gun and his fire, and he's got it in his holster. He just shows it to him, right? Now, he exits his vehicle and he goes over to that vehicle, right? The guy that just cut him off. And he said, Ronald's adult son got out of the passenger seat, approached the vehicle, driver's side of Dunning's vehicle within a few feet of the driver while pointing the handgun at Dunning. The defendant told Dunning to move his truck or he would shoot. Dunning, misunderstanding, believed the defendant told him that if he moved, he would be shot, right? The slight but critical misunderstanding explains everyone's subsequent actions. The defendant returned to his own vehicle and took up various positions, right? Got behind his own car, walked back, got behind his car in a prone position, aiming the firearm at Dunning. The Brethricks, Dunning, and several passerbyers all called 911, right? So the guy who went crazy, acted crazy, jumped out of his car, he called 911. It always happens, folks, right? The person who pulled their gun in self-defense, who was doing nothing, he called 911. And then several passerbyers, other motorists, they called 911, right? The defendant's mother, and when I say the defendant, this is the guy that got out of the vehicle with the gun, right, to protect himself. His mother and sister exited the vehicle and they took refuge in a ditch on the north side of the road. Basically, they were hiding. The defendant told his family that Dunning said he had a gun, but no one saw Dunning with a gun. The court ultimately found that to be not credible. So here's what happens, folks, right? This incident, this road rage, some guy jumps in front of you, slams on the brakes. If you don't hit your brakes, you're going to get into an accident, cause harm to your family, right? Shows a holster, right, with a gun in it. When the guy walks over, he backs up. It's sort of instinctual that now you might exit your vehicle and make sure the guy doesn't go anywhere, right? You probably get to aim the gun at him, right? And this is what he does. He aims the gun at him, but then he goes, yeah, let me back up because I don't know if this guy's got a gun, right? He says that the guy said he had a gun. So he gets behind his vehicle and he's aiming the gun. Guess what happens, folks? The police arrest him. I keep telling you, everyone thinks stand your ground. Oh, yeah, stand your ground. Nothing. No. What stand your ground means is that if the officer doesn't have enough probable cause to arrest you, he has to make a determination. You're dealing with police officers here, folks. You're not dealing with lawyers and judges, right? You're not dealing with people who have, a college degree and then a second degree in law, who have read case law, read statutes, have studied. You're dealing with a police officer who's had 6 months of training. He makes a decision. And that decision in this case is to arrest this guy. Crazy, but he arrests him. So now, this guy, Brethrick, he obviously has to hire attorneys, spend a bunch of money, because he's being charged with aggravated assault with a firearm. Okay, so now what happens? Well, he files what's referred to as a stand your ground motion, a motion to dismiss. And what happens is the court ultimately says, when he first raised the firearm up in the holster, right, while he was still in the vehicle, that was okay. But when he got out of the vehicle and walked over and aimed it still at the person, like, hey, don't you go anywhere, or don't move, or whatever he said, if you move your car, I'm going to shoot you, or whatever, because he's calling police, right? That part was aggravated assault with a firearm, because he didn't have a legitimate fear at that time that he was going to be harmed, as opposed to when the guy jumped out of the car angry and came towards him. But because he held the gun, continued over, aimed it at the guy, got into a prone position, dialed 911, help, some guy just cut me off and came after me and I pulled my firearm. Guess what, folks? He didn't win the stand your ground motion. So let's go down. I'm going to read down. The question ultimately became part of the burden of proof. So here's what happens. When you're charged with this crime, aggravated assault, and you want to put forth your affirmative defense, right? Stand your ground, self-defense. You want to put that forward. You now have a pretrial motion. It's called a motion to dismiss, or a stand your ground motion. What happens at that point is you, as the defendant, have to prove by a preponderance of evidence, meaning, right, like this would be like beyond and to the exclusion of preponderance evidence is just a little bit more than 50%. Like, for argument's sake, let's say 51%, but it's 50.01%. By preponderance, just slightly more than the other. You have to prove to the judge that you are entitled to have the charges dismissed. Well, the judge said no. And guess what, folks? This case went all the way to, let's say, Supreme Court of Florida, right? So just for those legal eagles out there, because you can look this up on Google, it's 170 Southern 3rd 766. Again, Jared Brethrick, petitioner versus State of Florida. So this case goes all the way up because he loses his stand your ground motion. And the issue that arises in stand your ground is whether the burden of proof, whether Brethrick has to prove it by 50.01%. Once a defendant satisfies the initial burden of raising the issue, does the state have the burden of disproving the defendant and is entitled to self-defense immunity of pretrial, as it does a trial? And the court said, let's see, ultimately the court said, let's get down to it. His motion was denied. He filed a motion for reconsideration. The 5th DCA concluded that under the procedure of stand your ground pretrial evidentiary hearings set forth in the Dennis case, the trial court properly placed the burden of proof on Brethrick, meaning he had to prove 50.01% that he was allowed to do that. And they found that the trial court correctly found that Dunning's actions did not rise to the level of false imprisonment, aggravated assault, or any other forcible felony. And therefore, defendant cannot justify his use of force on a basis. Hey guys, like, this guy didn't shoot anybody. This guy aimed a gun at somebody after, in effect, he was attacked. Dunning retreated to his vehicle, right? No one saw Dunning with a gun, right? Because if he would have had a gun, then he could have pulled it, right? But no one saw it. No camera. The passerbyers didn't see it, right? Dunning retreated to his vehicle when Ronald Brethrick held up a holstered weapon. The trial court properly determined that there was no longer an imminent threat and that the defendant's subjective fear at that point was objectively unreasonable, right? There was at least one car length between the Dunning vehicle and the Brethrick's vehicle. When Dunning's truck rolled back not more than 18 inches, that action standing alone did not constitute the act of false imprisonment as defendant contends. Notably, the defendant's mother and sister exited the vehicle and took refuge nearby. Several other cars passed by in the 2 lanes on the other side of the middle lane, of course. Florida, right? No one cares about their fellow man. Where Dunning and Brethrick's vehicle sat. It was not reasonable for the defendant to believe that it was necessary for him to approach the Dunning truck with a gun drawn in order to defend himself or his family. Is this some bullshit? Hey, this is what's going on, folks. So don't think when you pull your firearm, I got my concealed weapons permit. I can stand your ground. No. You can stand your ground for a second, and if someone's coming at you with a gun, yes, you can fire. But listen to this. This guy cuts him off. Crazy. Almost sideswipes his car. Almost causes an accident. Gets in front of him. Slams on his brake. Comes at him aggressively. He can pull it for 1 second, and then the guy retreats. No, you can't. Is it crazy? I mean, I feel like some issues were missed here because I think that would be considered a breach of the peace, and I would think that I'd be able to make a lawful arrest. And how many officers pull their firearm to make a lawful arrest? So here, this is what the case law is. Now, there's another case coming out right now that is currently being held, and I don't know what the heck is the name of it, Spike's case or something. Let's see if I got a name on it. I'll tell you right now. There's a new case, and as of May 2020, we're in May right now. I'll tell you the name of this case. Sparks. Sparks v. State. Superseded by statute, stated in, let's see, when was this done? April 1st, 2020. It's not official yet, but there's going to be some more changing of the law and more clarity with the case law. So I'll probably talk about that once it's official. I could read the opinion, but they're going to mess with it a little bit. But folks, you need to know, stand your ground doesn't mean you can pursue. Stand your ground means you can stand your ground. So what does that mean in this case? When Brethrick was sitting in his car, he stood his ground. He pulled out his firearm that was in the holster. The second the other guy retreated, right, the Dunning guy, once he retreated and he pursued, it was no longer stand your ground. And this poor son of a gun got, convicted of aggravated assault with a firearm. Think about it. Stand your ground is stand your ground. You can't move. You can't pursue. You can't chase. You can't hunt down. No. You can pull your firearm and basically use as much force as used against you. You can show it. You can exhibit the firearm to scare the guy off. Once the guy goes, oh boy. Or think about it, folks. If he would have ran back to his car and started shooting, well, then he could have pursued and possibly fired. But in this fact scenario, the court said, no, stand your ground's not applicable. It's not a defense. Give lawyers something to argue about. So I'm attorney Roger P. Foley. I hope this helps you a little bit understanding stand your ground. And I'm going to talk to you a lot more about this. Thanks for listening. Oh, subscribe.